Good morning. We would like to welcome everyone to our first of a series of webinars at ALARIS. We appreciate you taking the time to join us. If you have suggestions for future webinars, questions, or comments, please do not hesitate to add them to the comment box. Following the webinar, you will receive an email with a link to the webinar for your review and for your colleagues and coworkers. Our presenter today is Neil MacVicar. Neil is an attorney and serves as Vice President of the MHA Unemployment Compensation Program offered by the Michigan Health and Hospital Association. Neil has represented and consulted employers in unemployment compensation law matters for over 26 years. His works includes consultation with individual employers, representation at hearings, and appellate representation up to the Michigan Court of Appeals and Michigan Supreme Court. It is our privilege to introduce Neil MacVicar.
Thank you, Terry. Appreciate the introduction and appreciate everybody joining us this morning. Again, my name's Neil MacVicar, and I've been practicing unemployment compensation law for a long time. I just want to point out that my area of expertise is unemployment compensation and not necessarily insurance law and things like that, but Terry did approach me a while back and said that she'd like to have a presentation that just pull the layers back about what unemployment compensation is all about and dig into unemployment so all of you can have a better understanding of how that system works, but then have an idea of how it might be applied to no-fault wage loss claims. And the one thing that I want to point out before we begin is the interaction between unemployment compensation and no-fault wage loss is definitely a gray area. So the purpose of today is to, again, give you some insight on the unemployment side. What are some of the factors that are considered when an unemployment claim gets filed? And then to present just some concepts that we'd like to have you consider. So hopefully everyone can see the slides. I'm going to periodically check to see if there are any questions. If you do have a question, you can pose that online there, and I'll keep my eye open for those and answer those as we go along, or may reserve to answer questions at the end. So the title slide there, we'll be looking at some opportunities for cost savings. I'll just move into, hang on just a moment. Slide number 2, I just wanted to point out that, again, as Terry mentioned, I'm with the Michigan Health and Hospital Association. We represent employers throughout the United States, and again, particularly in unemployment matters. And we do a lot of representation at the hearing level. Who funds unemployment benefits? Again, nothing is taken out of an employee's paycheck to fund unemployment compensation. Unemployment compensation is funded entirely by the employer. And that's done through 2 different means, and we'll look at that in a minute. But the point here is that employees frequently, when they lose their job, they frequently think, well, they paid into the system, and in actuality, they didn't. It was the employer paying into the system. Now, there's 2 means for employers to fund the unemployment system, and then this is typical in all states. The unemployment agency in all states treats for-profit employers a little bit differently than not-for-profit and governmental employers. So the first thing that we're going to look at is the for-profit employers. For-profit employers throughout the U.S. pay a payroll tax, and there's actually 2 payroll taxes that they're paying. One is a state payroll tax, and that payroll tax that they're paying to the state funds the benefit payments made to claimants. So here in Michigan, if an employer is paying that payroll tax, that tax goes into a state trust fund that's held only to pay benefits to claimants, and it's not used for anything else. And as you can see, in Michigan, as an example, the payroll tax is assessed on the first $9,000 of each employee's wages. So typically, an employer is paying that payroll tax in the first and second quarter of each calendar year, because that's the period of time that employees are earning their first $9,000. And the payroll tax has, got quite a range there, and it's experience-based. There is also a federal payroll tax, and that amounts to $42 per employee. And that payroll tax paid by the employers goes to Washington, D.C., and then that money comes back to the state from the Department of Labor in grants to fund the administrative costs of running the unemployment system. So the judge's salaries, the paper that used to issue determinations, that comes from that federal payroll tax. Then there's the other employer group, and that's called reimbursing employers. And again, this is going to be not-for-profit organizations, so hospitals and schools and universities and churches and things of that nature, as well as governmental entities. And they don't pay a payroll tax, either at the federal or the state level. What they do is they are charged unemployment liability by the state only when claimants receive benefits. So every time a former employee of a school receives an unemployment check, the state then turns around and sends an invoice to the school to reimburse the state unemployment trust for the amount of that check. So again, those are the two different types of employer charging means, and again, those apply in most states. I just wanted to briefly go over how do unemployment claims work, what's the appellate process and things like that. So as you'll see on the screen there, when someone files an unemployment claim, the state issues what we call a monetary determination, and that's notice to both the claimant and to the employer that a claim's been filed. It indicates to both parties that the person's either entitled to benefits or not, and will notify both parties the amount of benefits the person will receive on a weekly basis, and will indicate for how many weeks the person will be entitled to benefits. So that's the initial notice of claim. Now, if an employer disputes that claim, for instance, if someone was discharged for theft, technically they shouldn't be entitled to benefits. So if the claim comes in and the agency's allowing benefits, but it was a discharge for theft, the employer can then protest or dispute that claim, and then the agency will issue a series of determinations and redeterminations after the protest is filed. And if there's a dispute, it can go to an administrative law judge. Administrative law judges hear their cases on a de novo proceeding method. And then even after the administrative law judge, there are appellate means after that. And here in Michigan, you could go into the circuit court, the Michigan Court of Appeals, and up to the Michigan Court of the Supreme Court. So there is a very formal process for adjudicating unemployment claims, and both parties can dispute the agency's findings. Waiting for my next slide to come up here. Now, this next slide is a slide that just is letting you know what is the value or the cost of an unemployment claim to an employer. So first of all, unemployment benefits, those again are intended for a temporary partial wage replacement. It's not permanent by any means, and it is not full wage replacement. So in Michigan, the maximum number of weeks a person can collect unemployment within a 52-week window is 20 weeks. As I've got noted here, most states are 26 weeks. Michigan's a little bit unique. So in a 52-week window, you can collect up to 20 weeks of benefits, and the maximum benefit rate right now in Michigan is $362 per week. Now, not everyone gets the 20 weeks, not everyone gets the $362. What I'm showing here is the maximum claim, and so what could be charged to an employer's account is up to $72.40. Now, to get an unemployment check, again, you can be awarded up to 20 weeks of benefits, but there are certain hoops that you have to jump through. There are certain eligibility requirements. And eligibility is a term of art in the world of unemployment compensation. So the bottom line is, and to be a little sarcastic here, an individual can't be a couch potato and collect unemployment. An individual can't hang out on their pontoon boat all summer long and collect unemployment. There are certain things the person has to do to get that unemployment check. And again, the encouragement behind all this is to get individuals back into the workforce. So let's discuss the eligibility issues, that term of art. And there's four major eligibility issues. The first one is you have to be physically, mentally able to perform full-time work. And the full-time work is a requirement here in Michigan. Now, I've got noted in the second bullet item there that it can be a troubling area for employers, and I'll give you an example of that in the next two slides. But I also want to point out the third bullet item. Whether someone's able to perform work or not does depend on the employer's industry. For example, here in Michigan, hospitals run 24 hours a day, 7 days a week. So a person has to be able to perform full-time work on any of those three shifts. So if you have an individual that cannot work the night shift for some medical reason, technically they wouldn't be entitled to unemployment benefits because a hospital worker is expected to work any of the three shifts. So again, the first eligibility requirement is able to perform full-time work. And let's look at a couple just examples to better define what that means. So I want to tell you my story. So this is my real life story, and let's kind of dig through this for a second. I'm an attorney today, and I was on a ski trip last week. Now this is not a picture of me, just a canned picture off the internet. But last week, if I was on my ski trip and I broke both of my legs, technically I wouldn't be able to perform a full-time job because my job requires that I drive around the state and I be able to get in and out of different client buildings and things like that. So if I filed an unemployment claim with two broken legs, I wouldn't be able to collect benefits because I'm not able to perform full-time work. But that's not the full story. In the world of unemployment, we don't look at just the last job performed. What we do is we look at any jobs that the person has done in the past and ask this question. With two broken legs, can Neil do any job that he's done in the past? And if so, I may be able to get unemployment benefits. So back in high school, one of my jobs was I delivered balloons. Now, this is a long time ago, and this is, again, not a picture of me. I didn't dress up like that, but I was a balloon delivery guy. Now, could I do that with two broken legs? Absolutely not. So that job in my past experience is not going to help me get unemployment benefits. But I had another job when I was in high school. I worked at a movie theater in the box office. So I would go there, once a day, park myself in the box office window. I would take people's money. I would give them a ticket. They'd go into the show, and when they came out, they'd wave or whatnot. So what I would be able to argue today is, with two broken legs, I could perform the movie theater box office job. So technically, with two broken legs, I'm able to perform full-time work in a job that I've done in the past. So I would be able to get unemployment benefits because I've got that job in the past. Again, get my wife to drive me to the movie theater. I'd crutch myself in there and do the job. So there's an example of how this can be a little frustrating for employers in the respect that the unemployment agency can dig way back in someone's past, find a job that they could do with two broken legs, for example. Now, the other thing another example I wanted to point out to you, this is more of a real life transferable skill. I just wanted to mention, here in Lansing, Michigan, there may not be any movie box office jobs available. They may be all taken. So the unemployment agency will award me benefits if I can make a good faith argument that there's some transferable skill that I could take. So there may not be any movie box office jobs, but I could argue that I could do something similar. For instance, a parking lot attendant. Have my wife drop me off, crutch my way into the box, take people's money, watch them park their car, give them a ticket, and so I could do that job. It's a transferable skill. So again, it doesn't have to be the exact, it just has to be in the neighborhood. And I think that you guys probably see that in other areas of your work too, the transferable skill. The next example I want to give, and again, we're still on the issue of, are you able to perform full-time work to get unemployment benefits? And again, I just wanted to show another example here. And this is a live example from a recent hospital case. So there was a certified nurse assistant. Again, she has to be able to get around the hospital and help people lift themselves out of bed and do daily life activities, bathing, feeding, and things of that nature in the hospital. So we had a CNA that on a weekend, she was at a family reunion and got an injury during a softball game. So Monday when she comes into work, she presents a doctor's slip. The doctor's slip says, hey, she's been injured, no lifting over 5 pounds, no standing, bending, walking, and you've seen that and you're familiar with those types of notes. So the hospital looked at this and said, we can't allow her to work. So she's now off of work. She was a relatively new employee, so she didn't qualify for a leave of absence. So what she did was she filed an unemployment claim. And so the unemployment agency looked backwards back in her work history to determine whether or not she'd be entitled to benefits. And they found 3 prior jobs. So on her employment application with the hospital, she indicated that, number one, she worked at Meyer as a stock person. Well, she couldn't do that with those restrictions, so that job wasn't going to help her. Number 2, she worked on construction sites. That wasn't going to help her. But number 3, in her past, she was a salesperson at a tropical fish store. So she was able to get unemployment benefits in that situation because she could show that she had prior experience in a job at the fish store where she didn't have to lift over 5 pounds and didn't have to stand all day and whatnot. So again, just another example of how the ability to perform full-time work comes into play on unemployment claims. Now I'm going to move to another eligibility requirement, and this is, hold on a second. It says able to perform full-time work. That should actually be available. So the factor here is you must be available for full-time work. So again, you have to be available for all 3 shifts if you work in an industry that works around the clock. If you worked in an industry that was only open from 8 to 5, for example, and let's say that you had some restriction that prevented you from working during the day, you can only work night. Well, then you wouldn't be available for full-time work because that industry is daytime. You're not available during the daytime. We also see this in situations where People are adjusting their work schedule based on family issues. Someone may want to be home during the day because of children and whatnot, and they're only available in the late afternoon, evenings, and things like that. Well, they're restricting their availability. They might not be entitled to unemployment benefits. So again, although that says must be able, it should be must be available. The next criteria is that when you're in unemployment status, you must be seeking work. Again, the unemployment agency wants people to get back to work. So you have to show that you're genuinely attached to the labor market. And so the first thing is, here in Michigan, you have to report to Michigan Works, one of their physical locations. Put your resume online with the Michigan Talent Bank. And then you have to present to the unemployment agency periodically some indication that you have been looking for a job while you're collecting unemployment benefits. So the agency does require people to seek work. Again, the intent is this is partial, temporary wage replacement. We are more concerned about getting people back to work. So again, you can't be hanging out on your pontoon boat. You got to be in the game trying to find another job. The next eligibility requirement I just want to mention is the leave of absence situation. So if someone goes out of work and they're on an approved leave of absence because of a medical situation, they're not entitled to unemployment benefits. If you're on an approved leave of absence, you're considered employed, or to say it a little bit differently, you're not unemployed. So you won't get unemployment benefits. Now, where this gets a little bit interesting is people that go on the FMLA leave, the Family Medical Leave Act, LOAs. Employers are required to give up to 12 weeks of FMLA leave. Well, if a person's out for more than 12 weeks, there are situations where the employment comes to an end. The employer will not extend the leave, or there's no other option, so the employment ends. In that situation, if you lose your job after a leave is not allowed, then you're deemed laid off by the unemployment agency. Now the question becomes, will you get unemployment? Well, then we move back to those two previous eligibility requirements. You may not be available or may not be able to perform full-time work. So those two other matters may prevent you from collecting unemployment, even though the unemployment agency is deeming that as a layoff. The other thing that I want to mention just briefly, and this has become very common in the last 10 years, there's this concept of underemployment, or what we call reduced hour claims. So you have individuals that are working in jobs, and let's say they're working 40 hours per week, and their hours get reduced for a period of time, or maybe permanently, so they go from 40 down to 30. In that situation, we see people filing unemployment claims to make up the difference in the lost wages as a result of the reduced hours. So I just want to show you just a quick example of how that works in Michigan. As I call it, it's mathematical gymnastics. So hang on just a moment. So what I'm going to do here is just present an example of how unemployment claims work. So if you have someone earning $25 an hour, if they work 40 hours a week, their gross earnings in a given week are $1,000. So in that case, if that person got notice that they were going to have an underemployment situation, their hours were being reduced, they would file an unemployment claim. They would be deemed eligible for 20 weeks of benefits. Their benefit rate would be $362. And then behind the scenes, the unemployment agency sets another number. And in this example, 1.6 times, $580. Now that $580 doesn't mean anything to anybody when the claim is filed, but you'll see where it comes into play. So example number one, let's say that next week, that individual, they didn't get any hours of work. So they went from 40 this week down to 0 hours next week. In that case, they have 0 earnings. Their unemployment benefit would be the full amount, $362. Let's go to week number 2. Let's say they get called in for 1 day of work. So they have 8 hours of work times $25. Their earnings that particular week is $200. So the unemployment agency applies this formula here. They take the benefit rate, the 362, and they reduce the earnings by 50%. So what happens here is they're reducing the unemployment 362 by $100. So that person will get 282 that particular week. The next week, let's say that person gets 2 days of earnings. So now they have $400 in that week. The unemployment rate is determined by this formula here. And now you see that 580 number come into play. It's 580 less dollar for dollar on the amount earned. The unemployment check is $180. And then the last example, if that person's called back to work for 3 days in a week, and three days would be $600. So now their earnings exceed that 580 amount. Once you exceed that 580 amount, you don't get anything in unemployment. So I bring this example up because there are situations in your business where you have individuals that are off for work. They may come back into the workforce in a favored work setting of some type, and I'm not sure, but their earnings may be affected by that. So I just wanted to show you how reduced earnings can impact an unemployment claim. All right, now we want to get into the gray area, and this is, we've now talked about unemployment and how it works, or some of the basic components on that. And so when Terry approached me, the question was, is there any interaction between no-fault wage loss benefits and the receipt of unemployment benefits? And what we find is it's a gray area. So let's just talk about a couple things. First of all, under the Michigan Employment Security Act, so the Michigan law that governs unemployment, a claimant cannot waive or release their rights to unemployment benefits. So an unemployed person is always entitled to file an unemployment claim and get a determination from the agency on whether or not they're eligible for benefits. So you could have someone, sign off that, let's say an employee gets fired, and they promise not to file an unemployment claim. And they sign off, and it's in writing. Well, they can turn around and file an unemployment claim, and the claim's going to get filed. So again, you cannot waive your right to unemployment. So once that claim gets filed, then as we've seen, those eligibility requirements come into play. And so as long as you meet those eligibility requirements, you could be receiving unemployment benefits. And so a question comes up, what if that person has a claim for no-fault wage benefits? Could there be a coordination? Well, without getting to the answer of could there be a coordination or not, the coordination would never occur on the unemployment side. The unemployment benefits would never be reduced. And again, that's because of that first bullet item. You can't waive your right to unemployment. So again, the coordination issue, it's a gray area. But let's look at a couple things here. So what issues should be considered when we're, sticking our foot into this gray area? Well, again, first of all, unemployment benefits are temporary, and they are entitled. They are designated for wage replacement. I mean, that's similar to wage loss benefits. Now, where there becomes a conflict is if someone goes and files a claim for unemployment, I mean, they're affirmatively holding out to the unemployment agency that they're able, available, and seeking full-time work. But on the other hand, if they're also collecting no-fault wage loss benefits, is there some assertion by them that they can't work for some reason? So there's kind of an inherent conflict between those two. We also see that in the work comp world too. There are times where an individual will be entitled to workers' compensation benefits and unemployment. Well, there's an inherent conflict there because the person's saying, hey, I'm able, available, seeking full-time work, but on the other hand, making a claim for work comp benefits. So one other factor, that's the third sub-bullet there, is, in the legal world, when you're looking at no-fault wage loss, some of the case law and thing indicates that if you're going to consider coordination with the no-fault wage loss, you've got to look at, first of all, statute. And as you're aware, under the Michigan statute, SSDI and work comp can be coordinated or offset. But now unemployment, the statute's silent on that. So you need to look at some of the case law. And some of the case law points to a situation where the question needs to be asked is the unemployment situation somewhat connected to the auto accident or the incident? So just as an example, again, there's a lot of text there, but let me just walk through. I mean, let's say an individual who's employed gets in an automobile accident. Well, they are going to be on a leave of absence from work because of their injuries. The wage loss benefits could come into play as a result of the accident. But later on, that person who was on a leave of absence with their work suddenly finds themselves unemployed, meaning their leave of absence exhausted with work, and now they are in a situation of unemployment. They don't have their job anymore. Again, as we talked earlier, when you're unemployed due to a leave expiring, then you're on a layoff status. So that person then, while they're collecting the wage loss benefits and gets notice that they've lost their job, may file an unemployment claim. So when they file that unemployment claim, if they are not able and available and seeking full-time work, they wouldn't get unemployment benefits. But as we saw in the real-life examples of Neil, the balloon delivery guy and all that, at some point, I may be able to do a job that I have done in the past. I may not be fully released from my doctor, but there's some job I could do that I did in the past. So now I go back to the unemployment agency and say, hey, I'm able, available, and seeking work in this job that I've done in the past. So now you may have a situation where someone is entitled to wage loss benefits and unemployment. And where this, now you have to look back and see, well, could there be coordination? And one thing that's interesting in this example is the wage loss benefits and the unemployment are interconnected in the respect that there was an accident and there was, medical situation, and that medical situation resulted in the loss of work because they couldn't come back from an LOA. So a very narrow example, but one that might be ripe for coordination. Now, here's the challenge for the insurer in the area of unemployment. First of all, the insurer, a wage loss provider, is not going to be a party to an unemployment claim. The only parties to an unemployment claim, there's three parties. There's the employee, there's the employer, and the unemployment agency. So it's going to be difficult for an insurer to even get any information about the unemployment claim. Here in Michigan, there is what I call a cloak of confidentiality and privacy around unemployment claims. It's only the claimant and the employer that are going to have the right to know and be able to get details about an unemployment claim from the agency. So you as the insurer couldn't just pick up the phone, call the unemployment agency, and say, I want to know everything about the Neil MacVicar unemployment claim. Did he file? Has he received any benefits? Is he claiming that he's able to work? Did he present any medical documentation? So an insurer is going to have a difficult time getting that information. So again, the problem for the insurer is, how are you going to monitor whether or not this person's getting unemployment benefits? And I've got a series of bullet items there, again, just raising some issues. Will the insured individual voluntarily and accurately disclose that information? I mean, maybe you do have clients and claimants that are willing to voluntarily disclose information. The other question that you would want is, I mean, how are you going to confirm what benefit was actually received by the individual? As you saw on the underemployment situation, where I gave the 4 examples, 4 different weeks, you can see that each week a person could get a far different amount of unemployment benefits. So each week the number could go up and down, so you'll never be certain how much they're getting. There's an inherent delay in information. Again, unemployment claims don't get paid automatically. As you see, the claimants have to jump through hoops and report information. So there's a delay in the payment of benefits and the weeks that the benefits are actually attributable to. You could have someone in benefit status collecting unemployment benefits, and suddenly there's some change in their life. I've got here, they may take a new job, may go on vacation, and suddenly the unemployment claim gets interrupted. And then finally, you've got the payments. You've got a 52-week window that a person can collect unemployment benefits. But the reality is, even beyond that 52 weeks, there's a chance a person could get additional weeks on what we call a second-year claim. I'm not going to go into that in detail, but again, it would be difficult for an insurer to get that information without some voluntary disclosure by the insured. So let's say the insurer wants to get that information. How could you go about doing that? Well, I think right now your only action would be to file some legal action, and then ultimately have a subpoena issued to the unemployment agency to disclose that certain information. But again, that would have to be a separate civil lawsuit where you'd be arguing fraud or misrepresentation or something like that. Then the next slide that I've got, I just want to kind of just wrap up with just some general comments. Again, I have not seen your policies. I'm not aware of what the policies look like between the insured and the insurer, except for the policy that I have personally. But I think current policies do have some release of information provisions. So the question I pose is, are those current provisions enough to require a claimant or an insured to disclose what their unemployment information is if you as the insurer want to know that? Another challenge is for future policies, should you be considering a provision that specifically requires the disclosure of unemployment information be provided to the insurer? So I guess if your current policies don't address that, or the current provisions for release are not strong enough, maybe you want to consider looking into this. And if there was a situation where coordination was ripe, Essentially what we're trying to do is to avoid the double dip, not paying the wage loss benefits when they're also collecting unemployment. But I think you first have to have some common incident or some interaction between the two. And as I noted earlier, the amount of money that's at stake here is up to $77,240. That's the most someone can collect in unemployment in a 52-week window. Again, as I mentioned, this is a gray area, but I think it's one that is prudent for you to at least monitor and consider along the way. And that wraps up the presentation. So if I've been watching the questions, I haven't seen any. I don't know if there's any way to verbally ask questions, but my email's there, my telephone number. People will be, are welcome to follow up with me. Again, I just need to make sure you understand my primary area is unemployment compensation. Terry, I'll turn it back to you. Again, I just appreciate the opportunity to present these thoughts and give you some insight on unemployment claims.
Thank you so much, Neil. We certainly appreciate your presentation. And also thank you for participating in our webinar today. If you have questions for Neil or would like additional information, certainly do not hesitate to either reach out to us or to Neil to get your questions answered or to get additional information. And just as a reminder, if you have suggestions for future webinars, please do not hesitate to let us know. And again, thank you so much for participating in our webinar today. ALARIS is here for you. Please let us know if ALARIS can be of any assistance to you with your case management needs.
Terry, can you hear me, Terry?
Yes.
There is one question. I'm sorry. Just real quick. There was a question posed. I'm just going to read it real quick just to see if eligibility is based on some prior job in the past, will the monetary determination still be based on the wages of the most recent employer? Not positive on the question. I guess what I need to, the way I think I can answer this is once a claim is filed, from a monetary standpoint on what dollar amount that person will receive each week is locked in based on prior employment before the filing. The only impact on the benefit rate after filing is whether or not a person receives wages or not. So from a monetary standpoint, when a claim's filed, they do look in the past to determine what the wages were, and that sets your benefit rate. The benefit rate's locked in after you file and only will be adjusted as you earn wages or have wages during the unemployment period of unemployment. So if that was the intent of the question, hopefully I answered it. If not, obviously you can follow up with me. Thank you, Terry.
Thank you. If there are not any further questions, we'll conclude our webinar today and certainly look forward to your suggestions for future webinars. Thank you so much.
Thank you.